Sorry for the interruption. We will continue with the discussion. Okay. It is a suit for damages. It is known as suit for damages or suit for recovery of damages. Okay. Now, when can we file the suit for damages? Suit for recovery of damages. When can we file? When the compensation itself suffices. Suffices means what? It is sufficient. That's enough. When the compensation, if the court orders for compensation, that would be sufficient for the loss or the damage incurred by me. Understand? So, when would the suit for recovery of damages be allowed under specific relief act? If the compensation itself suffices. Number one. Number two, the loss or damage is determinable. Now, this is very important. See, how will we know whether compensation suffices? We have to know. How do we get to know? When the loss or damage is determinable, automatically we know that the compensation suffices. See, for example, that is what I was just trying to tell you. If there is a movable property would be the best example because the loss or damage is determinable in case of movable property. Okay? So, the loss or damage is determinable in case of movable property and the loss or the damage by itself would be sufficient in order to cover up the loss or damage. In such cases, compensation would be available. Okay? Third one, what we have to keep in mind is the movable property should not be rare. I was just telling you about how easy it is to gauge the loss or the damage regarding movable property. Right? But if the movable property is rare, so how it should be? It should not be rare. If the movable property is a rare property, say some very antique piece of jewelry or say some idol, Kohinoor diamond and all these things, it's a movable property, Kohinoor diamond. But just because, suppose there is a loss or damage to the Kohinoor diamond, would we be able to say that, that's okay, I will give you compensation for that. You take the compensation and keep quiet. I will give you the cost also for the loss or the damage that has been incurred by you for the loss of Kohinoor diamond. Take the damage. Take the damages. Be happy in life. That's suffice. No. Why? Because it is a very rare. Kohinoor diamond is a very rare thing. So it should not be rare. It should not be very difficult to get. Should not be difficult to get. See, for example, certificates. See, these are all everyday examples, If you actually apply your mind, you can get very easy examples which will make you understand the concept that you are preparing for your exam. Okay? We will take, for example, the certificates. Now, certificates, whatever degree certificate or LLB certificate or whatever type of certificate it is, they are also again movable property. Of course, it is not movable property, it's a paper, but still the property is a movable property. So, if suppose a person loses the certificates, let me not say I or you or anybody. If a person loses a certificate, then probably he can apply to the court saying that I had given it to the college. Okay, I had taken admission into the college and I had given the certificates to the college. They have lost the certificates. Now can the court or you as the court, can you say, oh that's okay, get the duplicate certificate from the university, I'll give you the compensation for that. That would not be that easy to get, right? Loss of certificates is a big thing. Okay. Now, even though it is not difficult to get, it is it's a very different occasion, right? So, there is no contract or there is nothing between this thing. But what it is, it should not be difficult to get. It should not be rare to get. It should not it should not result in undue loss. See, loss of certificates is an undue loss, right? Because it has been given to the college and then there has been a loss. This loss cannot merely be covered by compensation. If a person loses the certificate and the court says, I'll give you the compensation, be happy. That is enough for the loss that you have incurred. Will that be okay? No. So what case should be filed for that case? It should be specific performance. Then the case should be for specific performance. Okay? Now, so these are the situations in which a suit for damages can be filed. Okay? Now we go on to the next one. Of course, who can file? Who can file a case under Specific Relief Act? Who can file a case under Specific Relief Act? Either party can file a case. Okay, either party to what? Either party to a contract. Okay? Otherwise, the person, the party who has a right, interest and or title. Right and or interest and or title. And or. Please be very careful while writing your exam. Right and or interest and or right title. Okay, because right title and interest may be there in the person together, or there may only be a right or only an interest or only a title. It can be anything, permutation and combination of any of these three. Therefore, we write like that. So, what should the party have? Right and or title or interest. Now, against whom? Against the other party. How will you determine whether the other party is against the other party? How will you determine this? Against existence of liability. See the common notation, when we say liability, immediately people think of money. Money is not the only liability which is there for the purpose of right to sue. Understand? Liability exists in the form of, again, right and or interest and or title. Now, why do I say like this? See, if you look at the specific performance, whatever we are dealing with, okay, a person is say asking for declaration and possession. Declaration and possession. A person files a case for declaration and possession. Okay. Now, in this case, probably the person doesn't have title, probably, but the person has the right. Okay, the person has the right, the person has the interest, and therefore he is saying, please declare me and give me possession. After this declaration, the person gets title. See, this way we can even go to P&C cases. What do you mean by P&C cases? Probate and succession case. Probate and succession case. Now you know what is probate and succession case, am I right? Whenever there is a no will which has been there, which has been left behind by the person who is dead. Okay? In that case, there will be a probate and succession case saying that please affirm the will. Am I right? Probate is nothing but affirmation of the will. So when I file a P&C case, I will be asking the court, kindly affirm the will, Your Honor. When I have this, when I say this, what do I have? I have the right, interest, title. All the three I have. How? As per the will. But what I want, I need an affirmation by the court saying that, yeah, you are the one who can succeed to the property. Nobody else can succeed. Okay? So I need it. Even though I have it, I get an affirmation. So what is there? Right, title and interest. Whereas in declaration and possession, there is right and interest. Declaration, after declaration, the title is got. Understand? So what the person should have, either the party should have the right, title or interest against the other party for whom the liability exists. When I am asking for possession, probably this person is liable to give back the possession. Liable to give back the possession. So now what liability is there? Is this liability for money? No. This is a liability for giving back the possession of the property to the plaintiff. Right? So in this case, the liability which is owed by the defendant is that of giving the repossession, giving back the possession of the property. Understand? So liability need not always be the money part. So what does this remind you of? This should immediately remind you of the consideration that we read in general contracts. What did consideration say? It can either be monetary or non-monetary. Am I right? That's why when we go to a shop, I ask for a Coca-Cola bottle and I give money. Now what sort of consideration is there? My consideration is money. If the shopkeeper gives me back money, would that be proper? No. What should he give me? Coca-Cola bottle. So what is there? Consideration can be monetary or non-monetary. Here if you go to see, possession is non-monetary in nature. Am I right? It is not monetary. So here the consideration is the liability. And what is the liability? Possession. Possession is non-monetary in nature. Clear? Okay. Next we go on to the we have dealt with the first one, that is possession. The second one would be specific performance of the contract. This is very easy since we have already done it in the general contracts. Specific performance of contracts, as I told you, it depends upon the contract itself. What in contract will you consider when you are looking at specific performance of the contract? The promise, the consideration, am I right? The promise, that's the consideration that has to be given by one party to the other party, by both the parties towards each other mutually. Okay? Now, this is what you have to determine when you are looking at the specific performance of the contract. What's the next one that you should look at? Performance. What about performance? Whether it is the whole performance which has to be done, or the part performance which has to be done, or the part which is deemed to be the whole. If you look at the video of general contracts, you will understand what I am speaking about. Okay? So performance, it may be the whole performance or the part performance or the part which is deemed to be the whole. So again, when you have to consider the specific performance case which is there before you, you have to consider what was promised by either party to the other party. And then you have to look at the performance. Okay? And third one, breach. First one is promise, second one is performance, the third one what you have to look up at is breach. See now how I am teaching you, you may not really connect to it. Okay? But you just observe how you are dealing with the cases as a practicing lawyer. Then you will understand what I am trying to tell you. Okay? Third one what you will consider, that is the same way you approach when you are a judge. This is how you approach a case in order to analyze the case. That is what we are doing here. Okay? So third one is breach. Here when you are looking at specific performance, What is the relief paid for? Specific performance. So first you should know what is the promise. Second, you should know how the performance has been done. Third one, what you should see is breach. Breach, whether it is anticipatory or whether it is actual breach. This is what you have to know. Then what you have to see? The remoteness, the distance, am I right? And the extent. When you are talking of the breach, anticipatory or actual, remoteness or extent of damage or loss automatically occurs. But before that, what you should look at is the whether there was any contributory negligence. Contributing factor to the breach. See, when you are talking about whether there was any contributing factor to the breach, what you should also think about is whether the doctrine of frustration. Doctrine of frustration tells you how the breach was caused. Whether the breach was caused by the party himself or whether the breach was caused due to the party who gave the contract or due to any intervening impossibilities, that is the events or the circumstances or happenings, not happenings. There are so many things like that, am I right? So, when you are talking, you can think about all these situations in which the breach was caused. So, when we are talking about the doctrine of frustration, you should think about whether the party himself caused the breach, whether the other party contributed to the breach, whether there were any events or circumstances which led to the breach, and whether those circumstances were within the control of the party or beyond the control of the party. Am I right? So when you are doing within the control of the party, then the breach caused is said to be a breach, proper breach. But if it is due to any causes which is beyond the control of the party who caused the breach, then the level of damages comes down. I am not talking about damage, I am talking about damages. Okay? The level of damages, that is the money part, the compensation which you as a judge will give, will come down if the cause for the breach is beyond the control of the party. Say what we call as act of God. Natural causes. We call them as the act of God or the natural causes. Flood, earthquakes, anything like that, which occurs due to natural causes. Landslides, whirlwinds, anything, storm, you can take anything as an example that will be deemed to be natural causes. Okay, and the second one would be anything which is beyond the control. Anything which is beyond the control of the party. See, one thing is if it is an act of God or natural causes, it's beyond the control of the party. One more example what I would like to give you is here. Beyond the control of the party, it may be leading to certain facts of the case. See, for example, if a sofa has to be transferred from somewhere in Siliguri to all the way to Bangalore. Okay, now in between there is a tire puncture, and the tire puncture happens in a mountainous terrain where you will not find any mechanic or anybody like that. Now, when there is a delay in getting the sofa, I complain to the consumer forum or to the civil court, wherever I want to, saying that there has been a delay, so I should be given damages for the delay. Okay? Now when I do that, what do I say? He says there was a puncture in the tire, Your Honor. He could have brought a mechanic and got it repaired. What got him so long to do that? Now, what would be beyond the control? The other party would say, no, Your Honor, it is beyond my control. I could not do it so easily. What would be the explanation? Your Honor, when I was traveling all the way from Siliguri to Bangalore, I had to pass through forests. I had to pass through mountainous terrains, if it is so. Okay? I had to pass through mountainous terrain. Not all mountainous terrains have mechanics everywhere. Now, if it happens somewhere on the highway or somewhere within the city, we can say mechanics are available. Right? But if it happens somewhere on a mountain, would it be possible? It would not be possible. So even though it is just the facts, it is not natural causes or act of God. It would amount to beyond the control of the party. Okay, a simple tire puncture would amount to beyond the control of the party. Same way with strikes, gerao, protests, processions, these civil war disputes, all these rioting, all these are all beyond the control of the party. Okay? Thank you.